In this video, we'll dive into the world of divorce and money, exploring how it can affect you and the options available to you. What you're entitled to in a divorce settlement. When the divorce is finalised, a settlement is reached regarding the division of money and assets. This settlement is based on two principles that can sometimes be in conflict: fairness and equality. There are two types of assets: matrimonial assets acquired during the marriage and non-matrimonial assets acquired before the marriage. It's important to note that non-matrimonial assets can still be included in the divorce settlement, especially if they've become intertwined with matrimonial assets over time. But does this mean that a man always gets half in a divorce? The answer is no. While any ex-partner could be entitled to 50% of the assets, it's not always judged as a fairest split. Each marriage and divorce is unique, and there are no fixed rules that apply to everyone. The division of assets and money depends on various factors and circumstances. One of the key concerns in a divorce is often the property. Who gets the share of the property if you divorce? Well, there is no standard rule for this. The division of property is not a one-size-fits-all approach. In most cases, one partner may buy out the other's share of the property. However, it's not uncommon for both individuals to continue living in the property for a period of time if the situation is amicable. Furthermore, if both individuals legally own the property, they can both retain the right to enter and use it. They're not forced to leave the property during the divorce process. Does it matter if assets are in the spouse's sole name? The answer is no. Even if the family matrimonial home is legally owned by just one person, it can still be divided between both parties. The argument that a property is a non-matrimonial asset doesn't hold up because both of you have been living in it as a married couple. If you're divorcing someone who has sole legal ownership of the family home, it might be a good idea to add a matrimonial home rights notice to the property. This notice, obtained by contacting the land registry, prevents the property from being sold until after the divorce is finalised. Is it legal to hide assets before divorce? Absolutely not. It's illegal to hide assets from your ex-spouse to prevent them from being divided in the divorce. This includes savings accounts, investments, antiques, and even cryptocurrency. Deliberately hiding assets can lead to penalties and consequences in court. During the divorce process, both parties are required to disclose all their assets and financial information. This ensures transparency and fairness in the division of assets. If one party suspects the other of hiding assets, they can request financial disclosure and, if necessary, involve legal and financial professionals to investigate the matter. Another important aspect to consider in divorce and money matters is spousal support and alimony. Spousal support is often awarded to the financially dependent spouse to help them maintain a reasonable standard of living post-divorce. The amount and the duration of spousal support can vary depending on factors such as the length of the marriage, each party's income, and their earning capacity, and their respective financial needs. In some cases, spousal support may be awarded temporarily to allow the dependent spouse to gain education, training, or employment opportunities to become self-supporting. In other situations, long-term or permanent spousal support may be necessary, especially if there is a significant income disparity between the spouses. Child custody and child support are also crucial considerations when it comes to divorce and money. The well-being and financial support of any children involved are of the uttermost importance. Child custody arrangements are determined based on the best interest of the child, taking into account factors such as parental capabilities, the child's relationship with each parent, and their overall welfare. Child support is typically paid by the non-custodial parent to the custodial parent to ensure the child's financial needs are met. The amount of child support is often calculated based on guidelines established by the jurisdiction's laws and considers factors such as each parent's income, the number of children, and any special needs that they may have. In some cases, divorcing couples may choose alternative dispute resolution methods, such as mediation or collaborative law, to resolve their financial issues amicably. These methods involve the assistance of neutral professionals who help facilitate negotiations and reach mutually acceptable agreements. This can be a cost-effective and less adversarial approach, allowing couples to have more control over the outcome of their financial settlement. However, if a resolution cannot be reached through negotiation or alternative methods, the court will make the final decision on the division of assets, spousal support, child custody, and child support based on the relevant laws and the specific circumstances of the case. Remember, every divorce case is unique, and the information provided here is a general overview. It's important to consult with professionals who can offer personalised advice based on your specific circumstances. Even with the most amicable of divorces, it can still be worthwhile to consult with a solicitor for expert advice on how to proceed. These days, there's many online solicitors that work out cheaper and easier than meeting in person. JustAnswer, for example, only costs £5 for a trial, which could be far less than a traditional in-person appointment. One of my colleagues used their service and saved over £270 on an outstanding parking ticket. I've linked that offer in the description, and if you use that, you'll also be supporting Money Nerd, so thank you.